Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode, episode 109, we're going to dive into a brief case study which really has too many permutations for me to really fully cover the subject in today's discussion, but we're going to look at a case for gifts to grandchildren when structuring an estate plan. Now, as always, this presentation is not intended to substitute for legal or tax advice. So, what do I mean by gifts to grandchildren? Well, to really understand this, we have to look at the typical estate plan structure and the problem that comes with it. Most plans are set up in a manner where at first death there's some sort of specific estate tax planning, maybe to create gifts to a spouse in a marital trust or outside of one, and then maybe gifts to everybody, spouse and children, in some sort of credit shelter trust, which would use estate and GST exemptions. And the intent is that future generations could also benefit from that credit shelter trust immediately and from whatever's left of the marital bequest or the marital trust. But the problem is that children already have it bad. They have to wait until the second death to receive any devise or bequest from the estate or any share of a trust. Now, that's its own separate issue that we're going to talk about later, just because we're going to dive deeper into each child's family tree and looking at this. But one little point I want to bring up before we really dive into that is the potential for inequality, because the division at second death is often per stirpes or by representation, which ultimately down the road would favor descendant family units that have fewer grandchildren. In other words, if a child has fewer children, then each of their children are going to get larger shares ultimately, depending on how much that specific child uses of their share during life. Now, grandchildren already have to wait until their parents deceased to receive their share, but there could be a sprinkle trust. But that may not be a full benefit because the grandchildren's distribution priority is often subordinated to that of their parent during the parent's life. And in either case, the lifetime needs of that parent or even aunts and uncles in a larger common trust could substantially reduce the grandchild's share of that trust, in addition to creating all sorts of disputes between beneficiaries and maybe with the trustee in terms of hashing out those distribution priorities. And also, as I mentioned, you have the per stirpital division creating inequitable shares for grandchildren. And I'm not here to advocate per capita division because that's a subject for another time. But either way, with all these factors coming into play, it may be good to explore maybe making specific distributions or shares to grandchildren under a will or trust at first or second death. So, if you carve those off at first or second death, then there's a variety of benefits that could come along, but there's a variety of issues that could pop up as well. It's not a perfect solution. Really, what I want to highlight today are some of the pluses and minuses so that based on a client's specific situation, maybe they could explore this avenue. Now, when you choose between first or second death may work better because it could allow for more intentional tax planning, but you could carve it off at first death, but you have to note that you have a larger pool. If you're going to make shares for grandchildren at first death, you may also want to consider making shares for children as well. Really, what the first death might work better for is a situation where maybe there's a second marriage or a blended family or something like that. But specific children's shares could be considered at first death, keeping in mind that it's not necessarily optimal tax planning, because even though the current estate and GST exemptions are 11.58 million and it'll go up to 11.7 million in 2021, the gifts made at the first death could mean a loss of the survivor's tax exemptions in making those gifts down the road and a reduction of the tax-free distributions that could be made at first death. Now, when you structure these specific shares for grandchildren, you can consider pecuniary amounts, which are specific dollar amounts, or shares based on percentages. Now, we'll look at both briefly at the end when we take a quick look at an example, but some of the issues and benefits from a tax perspective are that there could be a little bit better allocation and use of GST exemption practically, because the GST exempt shares could go already specifically to the grandchildren, and GST non-exempt shares could specifically go to children with more incentive for depletion so as to avoid any sort of taxable distribution or taxable termination down the road, or with the incentive to apply a child's GST exemption down the road to those non-exempt shares. Now, with all this type of planning, your drafting really needs to be on point, especially on this GST issue if you're going to carve out shares for grandchildren early. It's easy to kind of gloss over this point. Another thing that's kind of unsettled in the income tax world is that a pecuniary gift to anybody, especially grandchildren, could create issues with the acceleration of income in respect of a decedent. Now, in the worst case, what would happen there is maybe you have a retirement plan, like an IRA, and that's used to satisfy maybe a $500,000 bequest to a grandchild. And what tax law has kind of implied, it's not very clear, is that doing so out of an IRA could mean that you can't stretch out minimum distributions from the IRA, but that the entire $500,000 is taxable the minute you use it to satisfy a pecuniary share. Now, moving on from that, if gifts are planned at the second death, one benefit is that you have a longer runway to consider tax law changes and related drafting changes to react to how things look today versus how they might look in a future when you take into account grandchildren's shares. And when percentages and formulas are used, that could be good from a tax perspective and economic perspective, as we'll see in a few minutes, but you also run the risk of shortchanging children and even spouse if you make these distributions at first death. That could really be the case if you take into account after-born grandchildren, because if you have very fruitful children, then you could potentially end up funding many different shares down the road, many more than you anticipated when the estate plan was initially implemented. Now, from a non-tax perspective, one issue is that your grandchildren's shares may not have as good of an incubation of tax-free growth, which is kind of a tax-related issue, but is also an investment-related issue, because what's going to happen is right off the bat, grandchildren are going to start drawing from those GST exempt shares they're receiving instead of having deferred distributions from a GST exempt dynasty style credit shelter trust like you'd see in traditional drafting. Now, from a beneficiary's perspective, they rely on spendthrift asset protection, which is fairly settled and fairly stable state to state. But when you isolate shares of singular beneficiaries, such as grandchildren, that protection could be reduced, especially if precedents change in the future. So, for example, if you have a child and their descendants all as common beneficiaries, it's maybe harder for a creditor of one of them to try to pierce or disregard that spendthrift clause than it would be if you had a single beneficiary trust, as might be the case with a grandchild. Now, overall, economically, this could reduce intergenerational conflicts and risks of trustee misconduct, because you no longer have multiple generations drawing from the same pool of assets, and you no longer have a trustee who has to balance the needs of each respective generation and the individuals within each generation as well. But this isn't necessarily a perfect solution either when you break down the math. So I'll do a quick example here to kind of look at what I'm talking about. Let's assume we have a couple with a combined estate of $10 million. They have 2 children. So, under the plan as anticipated, each child would end up with shares of $500,000, assuming no trust depletion and immediate death after the plan is implemented. Now, if child 1 only had 2 children of their own, but child 2 had 5 children of their own, there's a huge disparity of what the second generation is going to end up receiving. So, if we assume no depletion, that means the children of child 1 are each going to get $2.5 million ultimately. But the children of child 2 are only going to get $1 million each. Now, as I mentioned, that could be eased a bit through a per capita type of division. Now, that's a subject for another time. What we're looking at here is, instead of altering the division formula, looking at early distributions to grandchildren so that the grandchildren don't have to wait until their parent dies or is predeceased to receive any shares. So, let's say maybe to reduce possible conflict, the married couple here say in their estate plan that $1 million will be carved off at second death for each grandchild. In that case, the grandchildren kind of end up in the same position they would have ultimately ended up with, but after taking out those shares for 7 grandchildren, the children only end up with $1.5 million apiece, which may be worse from their perspective, but it also means they don't have to balance their children's needs from their own shares. Now, Where this might go off the tracks is if down the road, child one or child two has additional children of their own, and ultimately, let's say maybe 4 more grandchildren are born before the estate plan takes effect. Well, now you have the need for 11 million for 11 grandchildren, but only 10 million of estate. So that means the children get nothing, and each grandchild's share might have to be reduced. So in a situation like that, percentage shares may be more optimal in order to fully fund each share and make sure that the right amounts go to respective beneficiaries without the risk of depletion of the estate at the expense of others in terms of how shares might ultimately be abated when it comes time to divide the trust or the estate. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of The 10th of an Hour, and I look forward to seeing you in the next one.